Okay, so I see some people beginning to join now. The numbers are increasing nicely. Just give another second or two. Of course, you can see this is part of the Neurodiversity Masterclass Series on the fourth Thursday of every month. And of course, it's in collaboration with ADHD Ireland, the Institute of Neurodiversity, Neurodiversity Hub in Australia, ourselves in UCD, and Maynooth University. And I'm your host for this evening, Timmy Frawley, joined of course by Ken Kilbride from ADHD Ireland and Beth Kilkenny from the college. This month, a big welcome to Professor Nathan Hughes. And Professor Hughes is a professor of adolescent health and justice, and is also the head of Department of Sociological Studies at the University of Sheffield. So I'd imagine, Prof. Hughes, you're very busy with those dual roles. Your research, of course, is at the interface between social policy, criminology, and developmental sciences, highlighting the disproportionate prevalence of various childhood health and development difficulties among young people in our criminal justice systems. So it's very exciting work, actually. And of course, I'm aware of some work in relation to children's interactions with the criminal justice system in the University of Limerick. But to hear it from a neurodiversity perspective, I think will be really, really interesting. So the format for this evening, if you would like, maybe take even up to half an hour to present, and then we'll have some time for Q&A. So of course, for our audience, do feel free to pop your questions into the chat. So over to you, Nathan, and thank you again.
Thank you. I'm going to do that awkward fiddling bit now where I try and find my slides and share my screen. Is that okay? Can we see that?
Yes, we can see it, and it's just onto slideshow now. So
perfect.
Over to you, and I'll turn off my camera so not to be distracting people.
You're okay. So yeah, thank you everyone. Thanks for the invite to join you today, and thanks for attending and for your engagement. I'm going to start with a couple of preemptive apologies. One of them, my children are in the house, so if they burst in the style that children do, I apologise in advance for the interruption. I also was just explaining to Timmy, never really sure how much expertise to assume, so I may say things that you all well understand, and I apologise if I do too much of that. And also, I kind of wanted to start with a brief kind of discussion about terminology and some of the kind of potentially the conflicting terminology that I'll use today, but the conflicting terminology that I use across my work, of tendency to kind of unhelpfully vary it to please the argument I'm trying to make at the time. And I think today I'm likely to do that as well. Given I'm going to argue about rights today, I'm going to mainly use terminology around neurodisability or neurodevelopmental disability. And so there are a couple of reasons for that I'll kind of run through, and then I'll pose a question for you to perhaps reflect on with me at the end. But so kind of choosing to use the term around neurodisability, well, firstly, I guess in opposition to focusing more narrowly on kind of particular clinical diagnoses of specific neurodevelopmental disorders. So trying to use a broader term than we might otherwise use if we were focusing in on those that have got that kind of clinical diagnosis that meet a particular threshold. And in doing so, deliberately interested in the experiences of those who either might not meet that clinical diagnosis, but might have a whole range of kind of disabling experiences, or who haven't been able to access any assessment that might get them that diagnosis, I guess. And then secondly, I use the term neurodisability when I talk about this work, really to link it to the kind of social model of disability, to kind of recognize in thinking about rights to justice that it's the kind of societal norms and practices and the discrimination that comes with that are at the root causes of the negative experiences of those who might be neurodiverse. So here, invoking all of those kind of systematic discriminatory processes that lead people to have an increased risk of criminalisation. And I guess that's key, and it goes back to the first time really that I engaged with this work with the Children's Commissioner for England, who was very keen that we use the disability term to link it so closely to the established legislative framework that we can then draw on to make the case for reform. But I say that now, recognising that your masterclass, indeed, the work from UCD focuses in on the notion of neurodiversity, and an increasing use of that term and among those with lived experience of such difference. And of course, being entirely supportive of the idea that we should reflect that difference as part of a kind of normal variation, rather than always, discussing it as though it's disabling. So as I say, conflicted myself, and I'm hoping that in the discussion later you can help me with that conflict a bit. I guess the last bit of that, the bit that I increasingly find tricky, is just why we add the prefix of neuro to disability. So I wonder if actually what I should be doing is sort of separating the concept of disability and using that when I'm talking about disability, and then talking about neurodiversity. And so that, just simply adding the prefix of neuro to a perfectly good word disability is perhaps countering its usefulness. But anyway, I've rambled on too long, and you can help me with that at the end perhaps. So on to something of real substance. So I guess I wanted to start with an advert for our work, and at the same time an acknowledgement of the various collaborators here that have helped me with it, and to frame our focus on disability today in a wider concern that we have about health and vulnerability in our youth justice populations. And that's not a new concern. It's a concern that people have been arguing for a while. But this article, which is open access if you link through and are willing to kind of register on the Lancet website, examines how kind of prior difficulties related to health or development in childhood and adolescence are associated with sort of subsequent involvement in the criminal justice system before the age of 18. So we try to kind of emulate and play on that kind of well-established social determinants of health framework to consider the health determinants of adolescent criminalisation. So again, for anyone who's unfamiliar with that, the social determinants of health basically refer to the conditions that people live in and age in, and the systems and policies that kind of shape those conditions, for which we can start to see the kind of social gradients of inequalities in health at a population level. So they include things like early childhood experiences, education experiences, employment, poverty within a family or within a community, those kind of factors that shape lives. So it's in this vein that we've kind of framed this review to try to identify the difficulties and experiences that might be related to health and development that make it more likely that a young person comes into contact with the criminal justice system. But like that social determinants framework, it's not to say that these health determinants are necessarily like causative. They're not necessarily the direct causes of criminality or criminalisation, though of course that they may have such an influence. But it's really about trying to shine light on the inequalities in the population regarding the risk at which they're going to be engaged in our systems. And it won't be a big surprise to you what those factors are. So neurodisability, which is clearly among them, but also challenges with mental health, experiences of trauma, experiences of various forms of adversity in childhood, from abuse and neglect to parental incarceration. So a range of kind of factors that suggest that actually some form of experience or multiple experiences of challenge in health and development are really the norm rather than the exception amongst the populations that we find within our youth justice systems. That it's our kind of most disadvantaged, our most unwell young people, children, who as a society we place within our youth justice systems and ultimately within our prisons. So our concerns with neurodisability and neurodiversity today I would invite us to kind of place within this broader concern about how we are responding to health and developmental needs among our populations, yeah, when we're responding to justice issues. But today we'll focus in on the factors around disability, and I won't labour these here because I'm sure you're well aware of this, and you don't need too much convincing. But the evidence of disproportionality in the criminalisation of young people with various forms of neurodevelopmental difficulty is pretty stark, pretty consistent, and increasingly sort of bleak. So in this table, we highlight particularly the stark difference between rates in the general youth population and rates among children in our prisons. And there are a whole load of problems in making these comparisons. It's very rare that you find a study that does this comparison for us. So we tend to have to compare studies that were as similar as we can get our hands on, and that often means slightly different populations, different definitions, different tools to measure, all those things. But even at the kind of the lower end of the youth custodial population and the higher end of the kind of general youth population, we can still see those differences, and they're large enough that we should be concerned. And this evidence is perhaps starting to be recognised, including through the good work of many of the folk who will be engaged with your activity, or at least they're starting to be recognised in international law. And it's this second paper in the same series as that first one that I'm going to kind of draw on sort of principally today. And again, free to access for anyone who's kind enough to want to read it. And in this article, we show, and as I'll do today, show how we've referenced to the recent general comment to the UN Convention on the Rights of the Child, the legal frameworks that we should be operating in, that each of our states should be operating in, have started to emerge. I guess a disclaimer that I'm not the lawyer amongst this group, so if there are any kind of complex questions about how international legislation works, I'm not going to be able to answer them, but I will refer you to Francis Sheehan, who did that hard work for me. But yeah, the paper is there for you to chew over. So probably worth, just as a bit of a backdrop, to mention the Convention on the Rights of Persons with Disabilities. Again, I'm sure most people here will be familiar with this. It provides us with the clearest and the best established framework for understanding rights around criminal justice, whether adult or child. It gives us a clear as we can get definition of disability in terms of how society responds to and interacts with a person's kind of particular impairment, including both those kind of more apparent physical barriers, but also aspects around attitudes and prejudices and exclusionary structures in our systems and so on. And it provides the first international human rights instrument that we should be kind of bringing to bear here. In particular, Article 13 is the one that relates to access to justice and tells us that access to justice for persons with disabilities entails the removal of obstacles and barriers faced as a result of disability, so as to ensure access to legal proceedings to seek and obtain appropriate remedies on an equal basis with others. So it requires the promotion of active involvement and participation, presenting this kind of notion of equal and effective participation in at every stage and in every role within the justice system. So it's not simply about a fair trial. It's not simply about rights to a fair trial, which is what most kind of human rights instruments are focused on. It's explicitly about notions of access to justice. So it talks about the need for that access to be on an equal basis with others. So the provision of procedural and age-appropriate accommodations that allow that access to justice. And it talks explicitly about the need for training for people at every stage of our justice systems around aspects of disability. We then have the more general kind of rights for young people inherent in the UN Convention on the Rights of the Child, which clearly also speak directly to criminal justice systems. And again, there'd be a framework that people are kind of generally familiar with. It's the most ratified, I think, UN convention kind of globally. Provides a very broad sense of rights, including rights of children who come into conflict with the law, and again rights around a fair trial, rights around legal assistance, rights around being diverted away from formal processes, And again, argues very clearly that these must be implemented without discrimination for all children. And that's about equal treatment for everyone. Again, it's not about equal treatment, but about providing the adjustments and the supports to allow equal access. So it's very clear about how we should frame the state's role in providing this access to justice. And it's in the context of these two bits of legislation, I think, that the general comment 24 on the rights of children in the child justice system landed. For those that aren't familiar, the purpose of these general comments is really to give an update and to provide kind of specific guidance for state parties on how they interpret the broader convention with response in relation to the more particular aspects of support. So here, children in the child justice system was a focus for how state parties should think about it, putting the UN CRC into practice. And the idea is that it allows for an update in terms of all sorts of developments since the previous general comment, which in this case was 2007. So it brought into it, explicitly says that it brought into it new knowledge about child and adolescent development and evidence of effective practice, and that one of these areas that there has been this kind of recent development in is clearly an understanding of, to quote them, developmental delays, neurodevelopmental disorders and neurodevelopmental disabilities. So it's something we're pleased about. We tried to provide a massive knowledge to the committee, and I'm sure others did as well, and thank you for those who put any effort in. So it was great that work has been recognised and brought into the legislative framework. So there are two key paragraphs that I kind of draw attention to here that have the intent of kind of guiding the implementation of the rights in the UNCRC, and they're relatively bold, I think. So paragraph 28 states that children with developmental delays or neurodevelopmental disorders or disabilities should not be in the child justice system at all, even if they have reached the minimum age of criminal responsibility. And that's a pretty bold statement, and one that's probably worth us coming back to. It's the idea of kind of automatic exclusion, which actually goes a bit further than we are usually minded to argue, particularly when we're talking to kind of national governments or our legal systems, who in the UK at least, and maybe Ireland has a slightly different framing, but in the UK would tend to be very averse to any kind of perceived idea of excusing crime and not putting someone through due process as a result of any kind of particular characteristic. So again, keen to hear your views on this and if and how such an argument might be made. Today, though, I guess I'm going to focus more specifically on the second part, which includes that if not automatically excluded, such children should be individually assessed. So it argues that an awareness of disability as experienced by the individual child is needed to ensure the protection of their rights without any kind of discrimination. And this then links to paragraph 40, which you can see there states that safeguards against discrimination are needed from the earliest contact with the criminal justice system and throughout the trial, and discrimination against any group of children requires active redress. And again, they note children with disabilities as a particular example here. So yeah, a long intro to what this means, but essentially, to our mind at least, it provides this a very kind of rich call to arms to all state parties, to all signatory states of the CRC, to address the needs of this population, as well as a requirement now to report back on progress through the usual checks and balances that the UN employ. And this is a big challenge, and one that, to our knowledge, few states have really grappled effectively with. And so there's a lot of work to do, I think, in both holding states and systems to account, but also supporting them to work out how they can do the things that this framework provides of them. I think it's probably a negative story that's going to follow now in terms of what the challenges are that need to be addressed, and it's perhaps overly so. I kind of sense that I'm not as up to date with what's going on, particularly globally, as I might be, and I'm always keen to hear more about promising practices that might might counter my overly negative narrative. I'll offer some examples of where we see some good practice, but I'd really be keen to hear any examples that you might have on this. But if we consider some of the ways in which there might currently be challenge that we might need to work on and address, the first challenge comes back to that idea that we need to be able to intervene as early as possible and remove children from our justice systems, which obviously begs the question how and when we might kind of effectively identify children who require either exclusion and diversion away or safeguards within the justice system due to aspects of disability. And I think it's probably still fair to say that screening and assessment that's able to effectively and in a timely manner identify any form of impairment or indeed diversity is rare within criminal justice agencies, again, particularly drawing on the UK experience and the Australian experience. We have some examples now of what are called diversion and liaison services in police custody that are trying to fill this gap, but research again even there suggests that services aren't universal and that they're patchy at best in understanding the full range of health needs that they might need to address. We've also tried to draw attention to where data linkage might offer new possibilities to ensure that kind of assessments and understandings of neurodiversity, disability in other parts of our children's services might inform our justice services. So how can we get information, if it exists, from our education systems, from our health systems, into our criminal justice systems? And the kind of integrated public service data systems that we see in some countries offer some possibilities here. And the work that's cited there is from New Zealand, where they've got a pretty well developed integrated system. But it's fair to say even there, they're probably at the research and innovation kind of space, rather than being something which is directly informing the practice of criminal justice professionals at the point of intervention. So they're not, it's not timely. And the last point there, I guess, is it reframes it slightly. I mean, assuming we're not in a position to assess everyone, how can we kind of most effectively skill up our practitioners to be alert to signs and signals, or to even to screen in an appropriate way at an appropriate point? So, for example, our police officers often play a really kind of key gatekeeper role in determining whether a person has a particular difficulty, and then deciding whether the subsequent response should be, arrest and police custody, etc., or referral immediately to a mental health type intervention. But again, speaking about the UK context in particular, it's clear that police officers are not routinely provided with sort of training or operational guidance that really helps them to identify, distinguish different forms of difficulty. Our efforts have really been around, or the efforts of charities that I work with have really been around trying to find the ways to encourage young people and indeed adults to communicate with criminal justice professionals about their to be alert and aware of their own condition and how they might kind of communicate that. We've also been trying to think about how we can put together structured assessment tools that can be delivered by non-clinicians in a relatively modest way, but that's again a struggle that we've not really kind of solved yet. The progress that we have made, I guess, is much softer, and again drawing on New Zealand as an example, arguing it's not necessarily that we need our professionals to be able to diagnose or to screen or anything, but just to be aware of and to interpret some of the presentational issues they may face in engaging with young people, trying to encourage them to reframe their assessments and understandings of what they might see when they're working with a young person, and to think about neurodiversity, neurodisability in how they frame their interactions. And this was part of a guide that we put together with the New Zealand Law Society for people who were playing support roles within police custody and courts, to really think about how they're, how they're understanding the young person in front of them. We also then would argue that we need to think really carefully about what the barriers to access to justice might be, and what safeguards might be needed, what might be restricting that access to justice. Research in various Anglophone countries, and again the UK and Australia and New Zealand in particular, has highlighted a whole range of disabling processes that would seem to increase the risk of criminalisation of young people with neurodevelopmental impairments. And again, in that context where effective and detailed assessments might be rare, and understanding of what to do with those assessments might be even rarer, there are significant challenges for those for whom various forms of functioning, but cognitive function in particular, may not correspond to the levels that might be expected at the age of criminal responsibility, or therefore match the assumptions about capacity to engage at a particular age, at the age that they are. So I guess what I'm saying is that our systems are based on a whole set of assumptions that lawyers and magistrates recreate in their everyday practice about young people's ability to engage, which is, would seem to be out of kilter with what the evidence would say about the young people that they're routinely seeing. So there's very good work across a number of years that's highlighted the particular terminology, the particular kind of conceptual language that can be really difficult for a young person to understand, and in particular a young person who might have particular forms of neurodisability, terms that people can misinterpret, and that can therefore have a big impact on what they're doing. That can include their rights at the point of arrest, like a Miranda rights in the US, which Wasilek and Turkstra have focused on. Sanger's work is far more basic, if you like. They talk about the kind of specific terminology and the particular language that young people with forms of difficulty might commonly not understand. Words as simple as penalty, verify, priority, caution, all of which would seem to frame the day-to-day discussions, but if you're not understanding them, then can you really be engaging effectively? Research has also highlighted difficulties in narrative language skills, so kind of the ability to tell your story, and how they pose real barriers in the context of the sort of forensic interviewing techniques that are kind of routine across our justice systems, applied routinely in courts and by the police. So I guess being required to tell a story chronologically about what happened with a particular incident and how that may or may not have led to a particular offence, and what you were thinking, what you were doing, and so on. Being asked to tell that story kind of chronologically can be very difficult if you have a particular kind of cognitive or executive functioning kind of difficulty. But if you're being quizzed in this forensic interviewing kind of way that requires you to break up that story and to retell parts of it over and over, and to answer questions on specific parts kind of out of that kind of chronological order, clearly that can be particularly difficult, and can be misread as, that inability to do that can be misread as lying, or the story not making sense if those difficulties aren't understood appropriately. There's also this research in Australia by Snow and Powell and others as well that have focused on how low expressive vocabulary or poor narrative language skills that might lead to these kind of monosyllabic, kind of poorly elaborated, non-specific responses, potentially poor eye contact and occasional shrugs of the shoulder, all the things that we would recognize as potential sort of presentational difficulties, related to neurodiversity, that they can be misinterpreted for deliberate rudeness or for willful non-compliance when being interviewed by the police or cross-examined in court. And if seen as kind of behavioural or attitudinal, rather than as a communication difficulties, then they argue that creates a real kind of additional disadvantage in that kind of passage through the system. And anecdotally, I don't think there's a good reference to this yet, but court workers in Victoria that we worked with have voiced kind of real fears that young people with the sorts of difficulties that might affect their ability to portray cognitive empathy in the courtroom. So empathy for their victim, might receive harsher sentences because of that, because there's a real kind of current emphasis on empathy and how you understand the experience of the other within those systems. So again, thinking more positively about what we can do. Of course, there's an array of adjustments now in place in courtrooms in various sort of settings across the world that try to address some of these barriers. And this is a recent paper that we published, Kim Turner and I, in Criminal Behaviour and Mental Health, that tries to provide kind of tentative evidence of the benefits of increased support for individuals, particularly with cognition and communication difficulties. And there's clearly, I guess at best our review concludes that there's a need for more research. Most academics conclude that, but in this case, we really lack a kind of robust and firm evidence base that we felt people could take to convince policymakers or governments to fund a greater kind of rollout of any kind of intervention. We've got lots of case studies, we've got lots of examples of promising practice, but nothing more robust about the impact of those practices. And of course, this is challenging. These are not delivered in ways that allow for very easy evaluation. They're not amenable to randomized control studies or whatever we might see as robust evaluation evidence. So really, our paper is a call to arms to be a bit kind of creative about that, to try and share these examples as best we can and build the evidence base accordingly. But more than that, I think our paper is an argument against trying to target specific interventions to try and find the perfect intervention to meet the support needs in court, and instead to start to think more generically about how we reform our day-to-day practices. So making the case that we should develop generic policing and generic youth justice procedures and practices and interventions that don't assume cognitive and communicative competence or norms or understanding of what's going on, or therefore to rely on an assessment or diagnosis to tell us that there's a challenge. If the rates that I presented earlier are anything like accurate, we should be assuming that the majority, if not the vast majority of young people coming into our courts are going to struggle, and we should develop our practices in a way that means that the far greater proportion can engage effectively. And again, we've tested this a little bit with the New Zealand Law Society, just trying to give again their professionals some pointers about how they might just change their day-to-day practice, some things that they might do to make the journey of young people with disability, but indeed other young people too, better through the systems that they operate within. Time. Okay, I'm going to try and wrap up in a couple of minutes, but I guess the last stage that I wanted to focus on is then the interventions that our youth courts might then be suggesting. Access to justice in court is not enough unless sentences are affected too, and it feels to me that we're far from the point where our interventions are effective. So that lack of awareness of neurodevelopmental impairment, of disability, leads to a lack of understanding of the causes and the contexts that might be sitting behind so-called offending behaviour, or access to then specific specialist services and supports that might address those underlying causes. And that's to say, a young person's offending may be who is neurodiverse or has a disability. The causes of that offending may be exactly the same as the causes of offending for a whole load of other people, but there may also be specifics around their disability and their diversity that if we're not addressing, then those interventions are not going to work. So that's either about kind of specialist support, and or it's about reflecting on the learning support needs, if you like, for want of a better term, that might affect an ability to engage with a particular sort of intervention. And again, our work around, I guess, our focus around kind of brain injury and how we encourage services to recognise and respond to brain injury kind of really highlights the issues that might lead to in relation to information processing, problems with memory, problems with fatigue. That should all be used to frame how you're engaging with a young person and the nature of that support, not having too long a session, not assuming they remember everything from the time before, like slowing down the ways in which you're supporting them. Yeah, so we also highlight kind of particular issues around the use of approaches that, well, the kind of generic interventions that are often kind of highly verbal, that rely on verbal skills and verbal processing, or seek to utilize the metacognitive skills that young people are assumed to have, where people are able to reflect on their behavior. So thinking about their own thinking and reflect on that. The idea being that if you can get people to reflect on why they did certain things, then when you get into that situation again, you won't make the same decision you made last time. And these approaches can be inappropriate for some young people with forms of neurodisability. Partly this is to do with the fact that they might find it relatively straightforward to talk in the moment and in that kind of cold, that state of kind of cold cognition, if you like, to talk about what happened and how they behave and how they should behave. But then when they're governed by the impulsivity or the challenges that their brain injury might cause for them, when they're next back in that situation where the offending occurred, they're not able to bring the learning from the classroom there, and so the offence might still continue. So if we see if people are offending again, or if they're not able to engage in the support that they should be receiving, then we're likely to see those interventions not work. We're likely to see offending behaviour continue. We might see breach. So we see young people back in the courts again that serve them badly, and it amplifies the future risk of criminalisation, and puts them into this spiral that kind of summarising this kind of closing quote that where myself and Pratibha Chittabeesan have argued that the failings of the system to kind of effectively support those young people so as to prevent reoffending, then reinforce their involvement with the system and its continued failure to do so. So essentially you get back in front of a system that can't support you, and you get a higher dosage of the intervention that's not supporting you, and subsequent churn through the system that results in that the final resting place that those stats suggest, which is our custodial systems and our custodial institutions. I'll end there. I've got some questions for you guys on the final slide, but I'll come back to them if discussion allows us to.
So Nathan, thank you so much. That was a really wonderful presentation, and actually congratulations as well on your many publications. And the Lancet, of course, always stands out. I was surprised to hear about the high rates of traumatic brain injury, actually. I hadn't anticipated that. And I really was enthused by your work on structured assessment tools, which can be delivered by non-clinicians, because I think screening tools for children in custodial situations are so important if we're to prevent avoidable harms. I have lots of questions, but I'm just going to go straight to Bet and Ken to make sure we get into questions from the audience. Thanks, Nathan.
Okay.
Sorry, which one was go first? Bet, will I go first? Sorry, we just really get very quickly. Sorry. Good afternoon, Nathan. I have to say it was one of the few presentations I was actually thinking of turning my camera off and asking a question directly that I had, but I said, best manners, I better not do that. There's one in there from Caroline Fahy, and she says, do you have any data on autistic children or young people, adults in the criminal justice system? I saw you would have on your slides there certain data on ADHD.
Yeah.
Certainly I'm not sure they're quite as high as you would have myself, but
yeah.
I didn't see any figures on autism, so I thought that's an interesting question there.
Yeah, it's not within our review. We did. There are studies out there, obviously. I've summarised them in a earlier paper, like 10 years ago. It's called Nobody Made the Connection, which is the work that the Children's Commissioner has highlighted. It's funded that the bit that I talked about that kind of shaped how we were kind of engaging with these issues around kind of disability rights, etc. At that point, when we summarized it, the discrepancy, the disproportionality wasn't as great as those other ones that we've highlighted, and we weren't kind of convinced that the evidence base was that strong at that point. Actually, the paper that I referenced in the middle of that presentation is probably more helpful, and I can happily sort of share that with you, which is work that was led by Nick Bowden at the University of Otago in New Zealand, where they've used their integrated data system to try and understand where our systems recognize autism, and then they can attach that label to their case, and then seeing the relative risk of being at different stages of criminal justice systems with that kind of recognition and diagnosis. And he actually finds in that paper that the disproportionality is nothing like as high as it's assumed to be, or the kind of the association between autism and offending is nothing like as high as it's assumed to be. Again, I don't find it convincing, but be interested in your views on it.
Well, thanks for that. Just forgive me, we'll come back to that, but I just want to go to the next question, and this is the first one in from Jane, and it's a little bit of a hypothetical one. I like hypothetical questions myself, so it's in a fictionally less individualistic / community-led society, would it be possible that these children would not end up as criminal despite their disabilities? There may not be a decisive answer to this, as it's hard to qualify, so your personal opinion is very welcome. Could I put an addendum to that question? That if you were simply to apply the social model to conditions like neurodivergence, well, then you would say if you were to move and improve the world from a social perspective, well, then the neurodiversity or divergency wouldn't be an issue. So therefore, they would be open to criminal prosecution because they have everything else resolved for them. Yeah.
I mean, that's it, isn't it? I mean, any involvement in our criminal justice systems, tends to be about the failure of various other systems and supports that have got them there. I mean, that's a very bold and general statement, but it would tend to be that those, particularly at the sharper end of our youth justice systems, have been known to various other systems along the way. And if you've got those other systems right, then the police and the courts might have far less involvement. I think it's a really interesting question. I think I kind of alluded to it when I was talking about the general comment that we made all kinds of recommendations on the basis of the evidence that we tried to kind of put to the committee that were writing the general comment, and we never once argued for not defining young people who are neurodiverse ever as criminal or excluding them on the basis of disability. And I don't know if that's because we lack ambition, that we should be more kind of forthright in saying that that disability should mean that there's not criminality. And there's a body of work, obviously, around neuroscience and the criminal brain and so on that might kind of support that. But we've always taken the line more of that. You can demonstrate criminality with any form of disability, but it's more how the system might then respond to that criminality. That it's not necessarily an argument that engagement with the criminal justice system might not be supportive of desistance, or in some contexts it might even mean that services are received that wouldn't otherwise be received, where we have such high levels of demand for services and such tight criteria for access that it could well be that actually talk of the New Zealand context, that being in front of a court means that a service is received that wouldn't otherwise have been. So yeah, I don't think I've answered that question at all.
If I could maybe just sort of extend it just a little bit, and then I'll let Beth in, to be honest. You were talking about the children's rights for disabilities, and you were talking about paragraph 28. And I was just writing down, the child should not be in the system at all. Each child should be individually assessed. And I think that's an interesting concept. We've always said in ADHD Ireland that any child that comes before the criminal justice system should be assessed for ADHD. Is that something that's a good practice, good policy, or maybe just the ideal world?
No, I agree. I mean, I think in an ideal world, for sure, it's like the question that we're often kind of posing is where do you put the investment, or what's the most appropriate part of our system to do this work? Obviously, it's expensive if we allow the diagnostic industry to determine how we assess and where we assess and so on. Obviously, that can be very expensive, and money spent on that would mean money not spent on other things. But equally, it seems abhorrent that you might get as far as court, let alone custody, and not have had those needs assessed within a system that's criminalizing you. When we made the similar argument in schools, that we would argue that we see high levels of school exclusion among young people that have not been appropriately assessed at any point in their journey, let alone at the point where they're being excluded. So ideally, you'd want it early. Ideally, you'd want the assessment to be as early as possible. But failing that, I think your case for a kind of universal assessment at the sharper end of the system is a good one.
Okay. Well, thank you for that. I'll step out now and let Beth have the next.
Thank you, Ken. I'm just going to read some of the questions that are in the Q&A here, Nathan. So apologies if there's any overlap and things that have been discussed already. So Gregory is asking, given that each neurodivergent individual is different, would a collection of case studies assist awareness in the justice system or not?
Yeah, I think that's really helpful. I mean, we obviously, so what I haven't mentioned yet, but I'm involved in a couple of kind of collaborations, charity-led kind of collaborations where sort of training and awareness raising and so on are kind of key to the work that they do. And I think that's a really helpful kind of observation. It's one thing to provide the stats; it's another to provide it in a way that practitioners can engage with. And actually, my experience, I'm sure others' experience is greater than mine, but those kind of conversations when you can bring it to life and make sense of how a particular difficulty might be impacting on a young person, then you'll often see that kind of light bulb moment in the practitioner of, I've seen this before. I can recognize a brain injury, I can recognize ADHD in the presentation of some of the children that I've worked with before, perhaps those that I've particularly struggled to engage with, and now that I've got this new lens, I can make sense of that. And I think those kind of those case studies are the best way to do that, aren't they? They bring things to life. Yeah,
and I suppose connectedly, there's a question from Jane about steps being taken in public services, namely the police, to educate on neurodisability. Yeah. Is there any funding or interest in this?
Yeah, there is. I mean, again, I can only talk from a UK context really, but we've seen this kind of recognised in the UK increasingly. Whether we've got to the point of the training being sufficiently rolled out, but our own Ministry of Justice are starting to get it. They've mainly gone down the route of sort of specialist practitioners. So rather than what I was arguing for there, with kind of every police officer or every a representative in every court understanding this, they've kind of gone for a specialist practitioner for an area or something, with the idea that person then has a responsibility of rolling out some of that kind of expertise and knowledge. So we see, for example, we're about to invest in sort of specialists in each of our probation services, which are regional, but and the same in each of our prisons. But yeah, I mean, it feels to me they're not necessarily people who can then work directly with young people or adults even who might have particular needs, but they're there to kind of plant some seeds and share that knowledge. Yeah, I mean, clearly there are a myriad of organisations providing good training, and I'm sure there are many in Ireland as well. How we kind of draw that training together, and I guess one of the things we've been concerned with is the kind of internal competition, not just between charities, but also between different conditions or different neurodevelopmental disorders, where there's almost a kind of a hierarchy of who's in and who's providing the training. And you might provide training in one area, but then do those professionals then, are they able to translate that across the spectrum of neurodiversity? So we've been keen to come to think about how do it's about how do we work together, but also what's the appropriate route by which you educate? How do we bring the kind of neurodiversity lens that allows people to understand the sort of spectrum of particular conditions that we might be kind of concerned with? I think that's tricky certainly in the UK in the current climate of funding and the context of different charities.
Yeah, and Jane also has the question about she describes an experience of the police being called on an individual, a neurodisabled individual sitting in a play park, and the police were called on that person, and she asks, how can we work on educating the public on this presentation, and how much of the criminalisation of neurodisabled people are perpetuated by the reception they receive from the general population?
It's a really good question. I'm sure Ken's got a better answer than me in relation to that. But
feel free to step in, Ken, if you want to.
You're on mute, Ken.
No, as I say, I'm all on mute. But sorry, could I just? I was actually just looking at another question. Sorry, just part B of another question that we were talking about earlier. This one came in from Sue, and we talked about initiatives underway to make neurodiversity screening for children system mandatory. But the bit in brackets I thought was very interesting from Sue. And wouldn't this be the most cost-effective approach? And is there any research out there showing that screening for children with neurodiversity makes sense from a financial perspective?
Yeah, I don't know. We've seen there were some examples of the kind of cost consequences kind of modelling. And again, I know most about brain injury, and the Centre for Mental Health did a good piece of work that said if you're not providing that initial support, at the point of brain injury when it's first recognised, what might the cost consequences be of that, in terms of the relative risk of different sorts of outcomes, whether in criminal justice or unemployment or whatever it might be. And I can't remember the figure, but they put a pretty bold figure on the cost of every brain injury. And of course, we live in that world where the cost matters at the moment, and you've got to be able to make that case. I'm not aware of anyone that's done that particularly well, but maybe we need to take that challenge and think about what screening enables and what that might actually save. I'm feeling the need to be a bit bolder in
forgive me, just we'll go just a quick question. You were saying you had some questions for us, maybe come back to them. But Jane was asking, the human brain is not developed to the mid or late 20s. And I'd have to say, from the male perspective, I'm not sure if it ever develops at all. In the criminal justice system and other legal frameworks, is this considered trying for neurotypical individuals? And it does bring the question, in terms of, what is adulthood? Is childhood end at the age of 18?
Yeah, it does. So I've got a bit of a side hustle in kind of young adult justice, particularly for this reason, that kind of trying to understand what typical inverted commas brain development looks like, and what that says about offending trajectories and so on. And I think these things kind of need to go together as well, because we do the transition. I've talked about youth justice. The transition from youth justice to adult justice is a massive one, and I don't know of much work, maybe others in the room do, about the experiences of someone with neurodiversity in terms of the maturation from teenage years into young adulthood. So the brain's developing, and we make all kinds of assumptions about how that brain develops in the same way we do as at the age of criminal responsibility. So I guess in England and Wales, I don't know about Scotland, but England and Wales, we've seen quite a strong emphasis on young adults recently, partly fueled by that understanding of the neuroscience and how we can wow our politicians with neuroscience. But I don't think it's quite caught up with neurodiversity as well.
Okay. You were going to say it's some slides. You want to ask us some questions?
I mean, we've kind of touched on it in your questions. I mean, I've kind of posted at the beginning about the language thing, and I feel it deeply every time I talk about whether the language that you choose to use and what the power of that language. And I'm really interested in sort of views of you guys and people in the audience about the choice of language and what the power that language has, and the unintended consequences of it. Yeah, I mean, I have a colleague at Sheffield, Catherine Roswick-Cole, who frequently challenges me about the unintended consequences of particularly around this kind of intent for diversion, the kind of the deserving and undeserving populations that you can create when you start to create kind of cutoffs for, diverting out and so on. Yeah, and I worry about the language I use and the language that's taking hold in the system. And yeah, I recognise there's people in this space that know far more about this than me.
Sorry, can I just literally 10 seconds? We had an ADHD Ireland board meeting last night, and one of the items on the agenda was, should we be a neurodiversity charity? And the view we came was, yes, we are already a neurodiversity charity because we deal with people with ADHD. No, we're not in a position to answer questions on autism, dyslexia, dyspraxia, because that's not where our interest is. But we certainly would see ourselves as maybe reframing ourselves as a neuro-affirmative charity. So I think, next time you see us, would it be ADHD Ireland and neuro-affirmative charity?
Excellent.
Yeah, I mean, it's a very interesting question, and of course, you raised an interesting point about different groups in society, different trainings maybe taking prominence and precedence, and of course, how can we arrive at a situation where there's that universal equality and equity of treatment? And I liked your idea, Nathan, of, I guess, for example, reforming the courts overall so that they're more accessible for everybody, because some of the proposals you had in your slides, some of the ideas could support somebody, be they neurotypical or neuroatypical.
Indeed, yeah.
And certainly the language, of course, is always interesting too, because when we talk about disability, that has a certain connotation. When we talk about diversity, that has a certain connotation. When we look at a medical model versus a social model. What I found over the years is to take my lead from each individual themselves and to see what nomenclature the person might like. But of course, society and even our academic studies require that we almost use categories and labels and boxes, which of course might lead to stigma, the challenge of stigma. I don't know if it was Jane or was it Sue mentioned about the person on the park bench, and sometimes prejudice can arise, and of course the police might have been called out of concern. We don't know, but certainly language does carry. It's not neutral. It carries a lot of meaning.
Indeed,
Any other questions for us before we begin to wind up for the evening?
I think I'm done.
Sure. Okay, well, we've had a lot of really good questions from the audience this evening. It's been a really fascinating talk. I know last year there was the conference on neurodiversity and the criminal justice system. You spoke at that, right?
I did,
yeah, absolutely. I remember. I mean, sincerely, your work is very important because you're addressing universal issues which affect young people. And a colleague of mine, Sean Redmond in Limerick, is doing some work as well around the interaction of young people and the criminal justice system. And certainly, it's an area that a lot more needs to be done, because your concluding quote is one I'm going to follow up on that paper actually, and take a read of it, because I think your concluding quote really is powerful. Thank you so much for giving of your time this evening. One of my favorite talks. I hope everyone else has enjoyed it. You'll be getting the recording of the presentation, and thanks, Beth, for that. And of course, thanks to Ken as well for being here. Really good discussion, and hopefully we'll see you again, Nathan. Thank you so much, everybody, for your time this evening.
Thanks.
Okay, take care and join us next month.